Hi, everybody. Thank you so much for joining us today at our session for thinking about estate planning for our loved ones, specifically those individuals older than we are that might be our parents, our friends that we make sure are cared for over their course of their lifetime. Okay. And then additionally, after they pass, just making sure that their wishes are aligned. So let's get started. Let's talk a bit about what the session covers, okay? What legal preparedness is, what it means to actually step up and step in now at this time in advance of, theoretically things happening, health conditions declining. What happens if nothing is in place? We'll talk about how we can do essentially nothing and what that does do and what it doesn't do and the risks of that. The key documents that will be featured of what is essentially helpful to care for someone financially, healthcare wise over their lifetime. And again, after they pass, the differences between having a will, a trust, no plan at all, what kind of proactive planning we can implement, and how to take the first step. So let's get moving. 97% of people think and know that estate planning is actually important, but about only a quarter of them actually take the steps to actually do something about it. We're going to talk about what we can do during the lifetime to make sure that our loved ones are actually cared for in every respect and what we can do to make sure that that happens. And then additionally, after their lifetime. But let's put those two things into two different buckets. If you had to step in tomorrow, financially speaking, can we access accounts, pay for different expenses, apply for government benefits? These are all items that we can care for in advance if we have the proper documentation, namely a power of attorney that we're going to get into, to be able to step up and step in now. Because unfortunately, the reality is, we'll get into what that can be, but the reality is it can be too late. There is a threshold where now we've missed our mark and our opportunity to be able to assist our loved ones during their lifetime. So what does capacity mean? What is the ability now for our loved ones to be able to create and sign off on these documents, right? It's the ability to be legal of sound mind to be able to sign these documents. We are presumed to be capacity to have capacity until we don't, essentially. So I'll give you an example of something that might have come up in a lot of our lives. I know, unfortunately, it came up in mine, but we can have relatives that are unfortunately that have advanced dementia, for example, let's say, and they've gotten to a point where now they don't have legal capacity anymore. They're too far gone in their current states to be able to actually make those decisions for themselves. And now they're in a position where our only alternatives are looking to the court system for guardianship. Obviously, a very lengthy and expensive process that we want to avoid, okay, where we can take care of those decisions in advance while they do have capacity. It's great to think that, our loved ones are healthy. We don't want to think about it. Unfortunately, it only can take a matter of seconds sometimes. Think about, tragedies such as car accidents, etc. It can only take a matter of seconds sometimes from being able to care for somebody if something were to happen to no longer being able to do that. Let's talk about the financial bucket versus the medical bucket. So starting with the financials, you want to be able to access your loved one's accounts to be able to take care of them. I'll give you a prime example. There are times where we're going to need to be able to cash checks for our loved ones, pay their expenses. We're going to need access to those accounts to do that. We're going to need authority to be able to speak to financial representatives to do that. We don't have that without a POA, without that power of attorney that our loved ones can sign to allow authority for us to be able to do that for them. And then on the flip side, the medical authority. So we think about it in a really similar way to how we think about the financial authority. But again, here with the medical authority, we're allowing individuals to be able to care for us in advance. So for example, there's a statutory list of, who gets to make decisions for you if something happens. But maybe your cousin is a doctor or in the medical field that you feel very strongly should be able to make those decisions for you. They're not going to be able to do that unless you've given that advanced order for them to do that and signed that healthcare proxy. And then additionally, we want to think about what happens if we actually don't take those steps. So unfortunately, jumping back to the financial items, we're going to be looking at a guardianship here. It's a very expensive and lengthy process. It can take months to years, frankly, and involve courts to be able to step in and determine who that guardian should be. It can be incredibly contentious. We want to be able to avoid all of that. And we can do that by having that power of attorney in place. And we can actually have our decisions already prepared and made for us before we have to go down that go down that road of petitions, evaluations, months to years of court involvement. Frankly, if we're already in a position where our loved ones are struggling, the last thing we want to do on top of it is have to drag them through the court process, to bring ourselves through the court process. There are so many easier ways to handle it. And it seems like something that is so foreign. It's something that we don't want to think about. It's like, everyone's good and they're healthy and we don't have to think about these things. It can really flip so quickly. So we want to make sure that our estate plans are not just in place for after we pass away, but that we're covering these items now. The cost of waiting. There are direct costs to doing nothing, okay? If we end up having to go to the court system, and if it resonates with you just to think of it as sort of like a dollars and cents item, then the court filing fees, paying an attorney for a guardianship, all of the ongoing evaluations and reporting items, those are all going to add up far more than actually just covering your estate plan now. And then additionally, there are indirect costs, lost opportunities. If you can't access someone's funds to pay their bills, for bills to rack up, to not be able to access their assets, investments, we're taking so much time and opportunity lost by not having those items in place today. So let's talk about how we can actually do that, okay? There are legal documents, such as a power of attorney and healthcare proxy, that can allow those advantages right now, in advance, where our loved ones can tell us exactly what their wishes are and the scope of what they want us to accomplish for them, starting with that power of attorney, okay? A power of attorney is a document that authorizes essentially to the extent that we choose it to, because you can modify them, but every financial decision that one can make for themselves, you can give someone that authority to be able to make them for you. So I want to highlight the major risk and also the major reward of that document, okay? So on one hand, you're basically saying, I choose X person or X multiple people. We can, pick a few people at once or just one individual and have a succession order of, if this person can't step in, then they can step in. But we essentially are choosing those people to be able to act for us financially the second we can't do that for ourselves. And it's incredibly important to delegate and designate that authority in advance. Okay, so just again, to talk about the risk, giving those people that authority is certainly a great risk. But then the reward is that if we're in a position where we need to be able to take care of our loved ones, it happens like that. The reality is that these items can happen quicker than we realize. And these powers of attorney, I think about a client we had recently where we went from an estate plan within a matter of weeks to needing that power of attorney when a client was completely healthy, came onto an unfortunate medical situation just shortly after signing. And it was incredibly important to have that power of attorney present. These things happen. So again, major risk, but also really significant reward. And then as for the healthcare proxy, think of it as really similar to that financial power of attorney, but it's in the health world instead of the financial world. Once we have authority to be able to take care of our loved ones from that healthcare perspective, and once that authority is given, that's who the doctors will lean on to be able to make those decisions for them. And I know a lot of people will say like, oh, I kind of signed one before this surgery or that surgery. It's really helpful to have one that is the New York statutory one that we provide that you'll be able to sign off on and make those decisions. A little different than the power of attorney, just so you know, is that we're not actually going to delegate multiple people at once, or we can't, rather. We're going to make sure that we have a succession order for that one, that if one person can't act, another person steps up. And just keeping in mind, if we want those decisions made for us and we have an idea of who should make those decisions, then we're in a position to make those decisions now. And we might not be in a position to make those decisions later. Additional to that healthcare proxy, a very common accompanying document is the living will. The living will states that if you were to be in a permanent vegetative state with no hope of recovery, that you would not want to be kept alive in that position. Everyone has their own wishes. Some people might want to sign that, some people don't. But to some degree, for a lot of people, that's going to be a really, really crucial document. We can go, unfortunately, from healthy to not that healthy to vegetative state way quicker than we even want to believe. And then when we're in a position where we don't know and our loved ones can't answer us as to what they want, this is their advance directive to be able to say, no, I've made that decision and this is what I want. So that's a crucial decision to actually guide and assist the healthcare proxy in that way where they don't have to make that call if the individual in their health, in their lifetime, made that call for themselves. What lifetime planning provides? Just as a recap, the financial authority is clearly established. You've already designated exactly who is going to be able to care for you in that respect. Same thing for the finances, okay? One of the key and core benefits is that court intervention and court expenses out the window. We don't have to think about them once we've already done this, okay? Decisions can be made without delay. Unfortunately, specifically in the medical situation, sometimes things come up immediately. No fights in a hospital, right? We just make sure that we have that done already. And then families can operate with clarity and peace of mind, knowing that these items were covered. I know for a lot of people, bringing these items to their parents' attention is really difficult because they don't want to see themselves in that way, and we don't want to see them in that way. The way, honestly, to frame it for yourselves is just to know that you're actually caring for them when you do this. It's not the opposite. I know that's a lot for people to really think about. The reality of dying without an estate plan is very sort of, you're leaving it up to grabs, if you will, to what the state would say. So we've kind of covered what documents we would use to care for during a person's lifetime, the power of attorney and healthcare proxy. But now, what would be used after they pass away? What would be used now to make sure that their assets are carried on accordingly and are cared for accordingly? So we have a will, which I think a lot of people are familiar with as sort of being a core tenet of estate planning that a lot of people have used for a long time. And then we have the trust, which is certainly a little bit more modern than the will, that people are less familiar with, but has actually become a much more effective estate planning tool and a much more widely used estate planning tool. So let's talk about the default rules. Let's say we did nothing. Let's say you didn't have a will. Let's say you didn't have a trust. The New York statutes are going to determine who gets what. I'll give you an example. If somebody passed away, married with kids, and did not have a will, often, not always, but often, people want their spouse to be able to get everything, and then upon the passing of their spouse, for it to go to their kids. That's not the New York default rule. There is a piece that goes off to the spouse, and then there's a piece that goes down to the kids. So it's not so simple as, oh, we didn't have a will, just making sure that our wishes could still be effectuated. They actually can't, okay? You also have to go through the probate court when you have a will or when you don't have a will. It really goes either way. Essentially, you're going to have to go to court and present that this individual passed away and show that you should be the one to be able to actually care for the estate. A long, expensive process that, again, could be avoided. Again, like we talked about, the distribution follows those statutory rules, not necessarily our own. Court guidance is going to need to be accompanied throughout the entire process, attorney's fees, etc. And the assets really don't move until the court authorizes it. And that's a function of not having a will or even having a will, but at least with the will, we get to dictate the distributions. And I'll talk a bit about that. Let's say you did have a will. Okay, so now, we kind of think of it as like step 1, 2, and 3. Step 1, or the lowest level, is we didn't do anything. Level 2 is we have a will, but we don't necessarily have a trust, okay? So let's talk about the will. You can, with a will, designate who the executor should be, who should be the one representing the estate in court, where the assets should go. You can be highly specific about those assets. There's a lot that you can do with a will. However, you're still going to be stuck in the court system. It's just the reality. So for example, if you have a home and it's designated in the will where that home should go, you are still beholden to the court in the county in which you reside. So it becomes effective at your death. It can name who inherits those assets, okay? It provides all of the written instructions that you would want, assuming it's properly drafted. It does appoint an executor, so it's clear who you want going to court. But again, it's stuck in the court system. We don't want to have to do that. So it's good, but then there's level 3. There's something essentially more effective. There's the trust. With the trust, you get all of those core benefits that you have with the will, where you get to dictate where the assets go. You get to dictate the control over those assets, but you don't have to have any court involvement. And what's really cool as a characteristic of the trust is that it's actually an entity capable of owning assets. So your trust, for example, might own your house, and the trust will dictate upon your passing where that house goes. These are all items that are important, not just for older individuals that are thinking about their estate planning, but for younger as well. I mean, we think about just wanting our assets to be passed directly and efficiently. That applies to everybody. And we're not going to get too much into this during this session. Obviously, in an individual session, we could talk about which trust is more effective for a given plan. But there are two kinds of trusts. You can have the type that's called revocable, where you can retain your complete control over the asset, or an irrevocable trust that you start thinking about Medicaid planning, theoretical nursing home stays, and how we could cover those. So there are different trusts for different individuals, but collectively they cover the same really great benefit, which is that the trust owns the asset and nobody has to go to court. Let's just do a quick comparison of all three and decide what might be best in our situation. So kind of like we said, there's level 1, 2, and 3. Again, if you take a look at the no plan item, everything is stuck in the statutes and based on what New York states, not what your family wishes are, and you're stuck in the court system. Additionally, with a will, you have all of your items discussed and lined up, and that's great. But again, stuck in the court system. Not a bad option for a lot of people, but also not necessarily optimal. And then with the trust, you essentially get all of those benefits. You're not stuck in court. You can separately distribute these items based on the trust terms. It's not public record like going to a court becomes. Your family privacy would be maintained with a trust, and all of your wishes are determined in advance. So there are ways to avoid court. The first being a trust. The second, having death beneficiaries on accounts is always really helpful and something we want to help our. That's a way to avoid court. And essentially the will only gets us part of the way there. And then certainly not having a plan at all is something we would never advise. And that's in your lifetime and also for a plan upon your passing. Let's talk about how and why we think it's important to actually take these steps now. There are ways to avoid all of the pitfalls of what we discussed. I mean, people talk about estate planning. They know it's important. Unfortunately, and we see it all too often, they don't get to the point of understanding the true importance until they're in our office and telling us that they have to go through the probate process, or mom or dad is too far gone to give us the power of attorney. We have to talk about guardianships. These are items that come up and that we think about as stressful items, but essentially they are stress reducers. And it's hard to think about it like that, but it's really a sign of loving our loved ones as opposed to the opposite.